On behalf of the Center for an Informed Public, welcome to the second of our interview series with leading legal scholars on the topic of misinformation and the law. We are here at William H. Gates Hall, the University of Washington School of Law, with Olivier Sylvain, who is a professor at Fordham Law School. He is presently on leave, serving as a senior advisor to the chairperson of the Federal Trade Commission. And we should note that nothing that Olivier says today should be attributed to the FTC or to the chairwoman. Rather, these are his own views. We're so excited to host Olivier this week. He is a highly prominent communications scholar. He has dual training in law and in communications. And he has, for some time now, been studying the issue of misinformation in the law from the perspective of marginalized populations, as well as liability by social media. So, Olivier, we're so excited to have you here. Thank you so much.
Ryan, I'm thrilled to be here. The conversations I've had with people here have been generative and interesting, and I will leave a better person for the visit. Thank you for having me.
My first question is, what drew you to researching misinformation and the law?
You know, I've, as you know, been a student of communications policy for a long time, and my concerns have been about the infrastructural deployment of systems that deliver communications to all kinds of communities, but especially those that are underserved. I am deeply interested in the questions of misinformation because historically, I'm concerned, as a general matter, I don't think I'm alone, that as with the deployment of infrastructure, the ways in which information is used has been to the detriment of historically marginalized groups as well. So misinformation about elections, misinformation about vaccinations, sometimes rooted in true historical facts, but as they populate our information environment today, not accurate. These are the kinds of concerns that have always animated my interest in information law and policy and communications law and policy.
So my next question is, what are you working on nowadays? That is to say, what is your present research agenda in the area of misinformation and the law?
So I'm particularly concerned about the disparate ways in which information is distributed to communities through social media. And the way the common language we have to talk about this is discrimination. But I'm really concerned about disparate distribution of information in ways that targets historically marginalized groups and or excludes them from opportunities. And so I've actually focused a lot on ads and housing markets, for example, where automated systems that prominent social media companies operate enable advertisers to target information based on protected categories. That's the kind of thing that drew me into this sort of work. I think that counts as disinformation in that the information is unevenly distributed and the harms are likeliest to be endured by historically marginalized groups.
Okay, so you're one of a handful of people in the United States who are studying misinformation and disinformation today. But in the past, you've studied other areas, and you're well known for a few different contributions in communications law and elsewhere. What are some of the similarities and some of the differences between studying misinformation and the prior work that you've done as a legal scholar?
Absolutely. The problem is the constitutional one for me. You gave a generous introduction of me, but as you know, Ryan, I'm also in the ACLU kind of universe. I do think of myself as a kind of civil rights, civil liberties person. Now, there is an internal debate within that group of people about what that means. But I am among the people who have worries about state regulation of information flows. And because while some of us have a view of what that should look like, we'll have disagreements about it, and should the state be in the business of deciding which information flows are allowed and which aren't? That's it's a tough question, and so this is distinctive in this area, right? I mean, it's exceptional in this area in the United States in particular, because of the concerns about state control. The reason I'm still comfortable weighing in on these questions now, however, is because of the extraordinary power some internet companies have that resembles state control, state power, or operates in furtherance of it. I mean, in any way, in any case, raises the stakes for the ways in which information is regulated by the state.
So, do you think that the First Amendment questions play out any differently on the internet? I mean, in other words, it's like ACLU v. Reno, the case that famously constitutionalized the internet in terms of free speech. Was it rightly decided? Was it wrongly decided? I mean, do you think these things play out differently here?
I do. I didn't. And the other piece of it that I didn't mention, but that that I care deeply about, is the doctrine associated with 47 U.S.C. 230, the Communications Decency Act. So the First Amendment is a part of the, as you know, the information regulatory regime. The one that overlays it and that actually channels it in one of its provisions is Section 230. And it plays out differently, just to answer your question directly, because there are few regulatory areas. I really struggle to find any through which, in which companies, as they are under Section 230, are free to host and enable, facilitate unlawful activity and not be held to account under law for it. So that's Section 230, and we can unpack that some more. But the First Amendment, in my view, in many cases, rightfully recognizes that some companies ought to be able to make decisions about how that information is distributed. But then how are they held to account, right? How are they held to account? That is not true in any in most other regulatory environments, right? So H-Mart, or not to point at any company, but Home Depot, Walmart, all of them are held to account for the stuff they sell and how their vendors market their products in their stores. Online intermediaries are not subject to the same kind of protection, and are able to do more, right? They're not subject to the same kind of legal oversight, and that's deeply concerning to me.
All right, my last question for you today is just, could you talk through, this is just for people who are new to the field, maybe they're new to the legal academy, maybe they're just new to misinformation law. What are some of the areas in the intersection of misinformation and law that you feel are under-examined or under-theorized?
Yeah, I mean, I like to believe that the project that I've been pursuing, that is informational inequality, is not discussed enough, and that's part of the reason I talk about it. The disparate distribution of information across groups in ways that track historical patterns of exclusion and subordination. There are people who are doing it, but it isn't part of the run-of-the-mill conversation, largely because of the kind of romantic view about what technology promises. All these historical facts still matter, and so it sounds like, I'm tooting the very area on which I work as an area that requires more research, but I do feel strongly about that.
Why would you do it if you didn't think that?
And similarly, though, had very helpful conversation with Kate and Mike earlier.
That's Kate Starbird, the director, and Mike is one of our researchers.
Right.
Yeah.
About how those are the communities that are harmed, but that this is a harm that is endured by everybody. That when information is disparately distributed, I think the humanist in me likes to believe that this is a harm that is endured by everyone. I'd love to know and think about how that's true. Maybe that impulse is wrong, but it's a deeply humanist one, right? It's why we might believe that discrimination is a bad thing, because it harms everyone. But I think that we need to build a theory of that again in our online spaces, because well,
I mean, so just one quick follow-up, because I can't help myself, as this area is so fascinating. So there's a long-standing conversation about the digital divide, wherein some set of people were said, maybe they're rural, right, but maybe they're poor, maybe they're marginalized in some way, don't have the same access to the internet, high-speed internet, right? And there you can tell a story about how if those folks are not full participants, then society misses out on their productivity, they can't apply for jobs, and hence the job pool is smaller, they can't get educated in the way that they need to get the information, and hence everyone is worse off, right? But it strikes me that your work is not just about can a person access the internet or not, it's a once they do. Right. So could you expand on that a little bit, how it differs from the digital divide?
Yeah, so I have a piece called Network Equality, and when I was still just writing about in-communications policy, that joined the debate about the open internet and network neutrality. In late 1990s, the head of the NTIA, Larry Irvin, coined the phrase digital divide. And at the time, he was concerned about the disparate distribution of physical infrastructure across the country and around the world. And it's not just brown and black people that didn't have access to the internet. It's also, as you say, poor rural white communities and all kinds of communities that are under-resourced. By 2000, early 2000 teens, that gap had closed. This is important for I think this point. That gap had closed largely because of the deployment of mobile devices, and you see that in the ways in the data about how people access the internet, or whether if they have just one access point to the internet, it's disparately distributed. The reason this is important is because most people appreciate that you can't do homework on a cell phone. That you can Zoom on a cell phone, but it's probably not as good as if you Zoom from a desktop or a laptop. Disparity manifests itself still, and alarmingly so, because of the physical distribution of devices. So access is, disparities still prevail in spite of the closing of the kind of gap that Larry Irving was talking about.
Yeah, and even if you were to be able to access the internet on equal terms, we see things like, for example, Asian American communities being charged more for services like such as test preparation services because of some algorithm that has decided that they're willing to pay more.
Right.
Or communities that are targeted for misinformation at higher rates can be racialized and genderized and so on. Is that part of what you mean? Yeah. Mm-hmm.
So one thing that you and I have talked about is the way in which our work has changed, right? And this is how my work has changed. I've talked a lot about infrastructure, but slowly have been looking at the consumer-facing problems of disparity and the price discrimination problem that you just raised with regards to Asian American families and access to child prep. I don't know if that's what you were talking
Indeed,
about.
Yeah.
Child prep services is facilitated by that kind of disparity is facilitated by automated systems that are not held to account under law because of Section 230 and a kind of romantic view about what technology promises. So that's kind of an account of how I got from one point to the other. But the disparities exist at the infrastructure layer and the applications and services layer.
Indeed. Well, thank you so much, Olivier. This has been fascinating. We so appreciate you visiting with us and taking the time to do this interview. So thanks again.
Again, I'm grateful to have been here.
you.